Very good afternoon, ladies and gentlemen. My name is Advocate Radhikesh Uttarwar. I head up Interlegal, which is a multidisciplinary and a full-service law firm based in Pune. I also practice as an attorney before the District and Sessions Court, Pune, the Honorable Bombay High Court, and the Honorable Supreme Court of India in various civil matters and family-related matters. The purpose of making this particular video today was that I have been receiving during this lockdown queries from several of my clients who are businesses who are anticipating trouble in recovering dues which are due to their respective businesses after this particular crisis is over. In other words, there may be cases where a business has supplied some goods or services, but payment is due and could not be made during this particular lockdown. There are cases where part payments were received, but the balance payments were kept on hold. There are cases where friendly loans were extended to other businesses and checks which were received, the other businesses are requesting them not to be deposited in view of the current crisis. Now, even though we cannot ignore the fact that several businesses today are facing a very genuine problem where cash or liquidity is concerned, we also cannot be ignorant to the fact that the moment this particular crisis comes to an end, we will be looking at a huge influx of people, businesses, or even normal individuals who will look to the justice system to assist them in recovery of dues which they otherwise should have received. And in order to clarify on some of the provisions that are available to a business or to an individual for effective and speedy recovery of monies under the applicable civil laws, I have decided to come out with this video, which is going to be one of the first videos of an instructional sort of series to answer queries that I get on a repeated basis. So let's start off with what are the scenarios which a business will usually go through and which ones are applicable to the topic at hand today. So first of all, there are businesses who have raised commercial invoices. As we are aware, in most business transactions today, it is a matter of trust where there is no written contract. Purchase orders are sometimes considered a technicality. Acceptances are considered a technicality. Most business transactions tend to occur on a simple invoice. And in such cases, many businessmen, many of my clients have raised the doubt that in the absence of a written contract, to that effect, can I effectively and speedily, which is the operative part, recover my money from the person who is not paying me for any reason whatsoever. Now, a misconception that several of these people seem to have is that if a particular person in the course of a business transaction does not or is unable to repay money which is due to a certain person, he or she becomes criminally liable, and that you can file a criminal complaint against such a person. So at the very outset, I'd like to set out that in commercial transactions, which are mostly of a civil nature, non-payment of money by itself is not a criminal offense. I will deal with what constitutes a criminal offense and when you can avail of the criminal justice system. However, a lot of people seem to think that lodging of a criminal complaint is the only efficient and speedy method to get somebody to pay amounts of money which are due to them. This, unfortunately, is not always true in practice. And today's video, I'm going to try to make most of my clients and others who are watching this video aware of a provision in the Code of Civil Procedure 1908, which is the essential bedrock of our civil justice system, under Order 37, which deals with a type of proceeding called as a summary suit. Now, many people have this ill-founded belief that a civil proceeding on an average would take anywhere between 10 to 12 to 15 years. Now, unfortunately, if we look up the data available on the Judice system, it is found to be true that while regular suits do take an inordinately long time to proceed through the judicial system, through the courts, there's always an appellate court where the aggrieved party can go and file an appeal. Then there is the second appeal which can be filed before a high court, and then there's the Supreme Court. So it does take a long time for civil disputes to reach a final resolution. But Order 37 is enacted specifically to ensure speedy justice, particularly in cases where there cannot be any doubt that a certain amount of money is due from a person to me. Now let me explain. Order 37, when you refer to a particular suit as a summary suit, the usual procedure which is followed in a civil trial, which is namely the submission of the plaint, then the opposite party or the defendant has about 30 to 90 days to file a reply, then there is admission of documents, examination of witnesses, so on and so forth. While this procedure is detailed out, a summary suit gets rid of the technicalities, allowing a dispute to come to a resolution via a decree of a court within a span of about 30 days, if indeed all the ingredients have been properly laid out before the Honorable Court. Now, what does Order 37 state? Order 37 basically refers to suits for the recovery of a specific amount of money, and I lay more emphasis on the word specific. The reason being that unless and until the amount to be recovered is specific, it is very, very unlikely for a summary suit to succeed, because the opposite party may always dispute the amount. So, first and foremost, the three conditions that are laid out for the institution of a summary suit in Order 37 are that a summary suit can be instituted upon a written contract, first and foremost. Secondly, it can be instituted upon an instrument, which may be a bill of exchange, a hundi, promissory note, so on and so forth. And thirdly, it may be instituted upon a guarantee which comes in force, provided that it is in the form of a debt, not a penalty. Now let me explain each one of these in a little bit more detail. So the first and foremost is the institution of a summary suit for recovery of amounts based on a written contract. This should be self-evident to most people hearing, that if I have a contract which states that if I supply X amount of goods, I will be liable or due to receive Y amount of money. Now this is simple. The factum is laid out, and as long as I can prove that I have supplied the goods as specified in the contract, I am entitled to the money that is mentioned in that written contract. So it's a simple no-brainer, which ideally should not take a very long time to adjudicate. The second one, the second type of summary suit which I mentioned earlier, was that which is instituted upon an instrument of business. Now, several types of instruments are in force in due course of business, mainly some of them being hundis or promissory notes, bills of exchange, checks even. I will tread carefully when I mention the word checks, because the law dealing with the dishonor of checks is under Section 138 of the Negotiable Instruments Act, which I will deal with hopefully in a subsequent video in more detail. But these are instruments. Now, in each of these instruments, the amount is very, very specific, and therefore each instrument is a clear admission of the other party's debt to you. It is presumed that if a particular check has been issued in your favor, and excuse me, and I repeat checks because it is a very common form of instrument used by businesses nowadays. If a person issues me a check for 10 lakh rupees, it is considered to be a admission of debt from that person that he owes me 10 lakh rupees, and therefore the task of the court is simplified in that the court does not have to adjudicate as to whether or not 10 lakhs is the amount. And therefore, summary suits can take a little lesser time. Now, the third part is on the basis of any, and of course, coming back to the written contract part of it, something that must be mentioned is that the Honorable Supreme Court has enlarged the definition of a written contract to even include acknowledged invoices. So it does not necessarily mean that a written contract should only be on a registered or a stamp paper for the supply of goods. There must be a purchase order. Even if you have raised an invoice, a proper statutory invoice, and it has been acknowledged by the opposite party, it can be considered under the liberal definition of a written contract for the institution of a summary suit. Now, the third part, which I said, was that on the basis of a guarantee in the nature of a debt. Now, several times businesses are required to furnish bank guarantees for their performance of a particular contract. These are of two types. One is where the guarantee becomes due compulsorily, meaning that if I do not perform a particular task, then the bank guarantee becomes due. Or two is where if I perform a task below the standard that is expected of me, then as a penalty, I will have to pay a certain amount. A very clear distinction in this case is that if it is in the nature of a debt, a summary suit can be instituted. However, if it is in the nature of a penalty for non-performance or for underperformance of a particular contract, then in that case a summary suit is not recommended, or rather cannot be instituted for the recovery of such dues. So we've looked at the first ingredient of a summary suit as to when, on the basis of what kind of contracts can it be instituted. Now the second part that we need to look at is the absolutely essential ingredient which is mentioned, is that the amount should be ascertainable by a court. Now, does this mean that interest cannot be included in a particular claim under a summary suit? Then the answer is the interest also can be included. So for example, if for late payment or for non-payment, a particular contract specifies that I am liable to get 8% interest per annum, then too the amount is ascertainable up until the point of the decree. So let's say 3 years it has taken from the amount was due to the decree being passed, then it is very easy to compute the interest applicable. So interest can also be included. It does not necessarily mean only a specific amount. It has to be ascertainable, meaning that it has to be easily computable, it has to be easily calculable by the court, and then a decree can be passed in that particular suit, summary suit. Now, what we need to look at is what is so different about a summary suit as compared to a regular civil suit. The first difference is that a summary suit is instituted for the recovery of monies, whereas a regular suit can be instituted for a variety of reasons, variety of causes as we call them. But a summary suit is specifically for the recovery of money. And secondly, the law guarantees a defendant in a regular civil suit the right to a good solid defense. However, in a summary suit, the defendant is expected to apply to the court and at the very first instance give reasons and state that he has a valid defense and apply for the right to defend. He does not get it as a matter of right. So therefore, in a summary suit, once it has been instituted and it has been filed under the guidance of a lawyer or of a counselor, the Honorable Court issues notice or a summons to the defendant from whom such monies are to be recovered. And once the summons has been issued and validly served, then the defendant has a period of 10 days within which he has to apply for the right to defend. Now, there have been several case laws on what constitutes a right to defense. And let me be very honest that in the event that a person is able to demonstrate to the Honorable Court that he has a defense, it may be a good defense or it may be a bad defense, but as long as he is able to demonstrate that he has a defense, then in that case, conditionally or unconditionally, the Honorable Court can grant him the right to defend. However, if the defense is a poor one, usually we will find that courts will impose a condition that a certain amount of money, which is undisputed, must be deposited with the court. Now, this has two benefits. One, it secures for the applicant, for the plaintiff, it secures that particular amount of money in the custody of the court. And therefore, you are at least assured that in the event that you are winning, that amount of money is safely in the custody of the Honorable Court. Now, if the person is able to put up a right to defend and if he is granted leave to defend, then in that case, the trial will continue based on such conditions as the court may deem fit. However, if the leave to defend is denied and if that person cannot possibly have any defense, so for example, in the example I stated before, if I have supplied the goods, I have an invoice which has been acknowledged. If I have a C form, I have a delivery challan which has been acknowledged, which clearly stipulates that I have supplied the goods and that there has been no communication or the goods have not been returned back to me as defective, faulty, or for whatsoever matter, and the person has used them, which is a reasonable assumption, then in that case there cannot be a defense for the other party excuse me, to defend that particular summary suit, in which case within a period of 15 days the Honorable Court can issue a decree, a final decree. In many cases, if the party does not attend, then an ex parte decree can also be issued in a summary suit within the same period of time, provided that the summons have been served upon that person, but he is still chosen not to attend. Now, this brings me to another point why I always recommend summary suits for businesses, is that in a regular civil suit, if a decree has come to be passed in the absence of the other person, which is what we refer to as an ex parte decree, then such a decree can be very easily set aside by the defendant subsequently coming before the court and saying, I'm sorry, I couldn't attend, and giving certain circumstances, and as a matter of right, that decree can be set aside. However, in a summary suit, when an ex parte decree comes to be passed where the person has not attended or even applied for leave to defend despite the receipt of summons, then in that case the person will be required to show compelling circumstances as for his non-appearance. He cannot just come before the court and say that I'm sorry, I wasn't there, can you please set it aside. It will not be set aside as a matter of due course. It will be set aside only when that person comes forth with a valid reason why he or she could not attend. And what is a valid reason, of course, remains to be decided by the Honorable Court upon the circumstances of each case. But this is another factor which helps in the conclusion of money recovery matters within a very, very short time period, provided all the ingredients are met. Of course, once a decree has been received, it is up to the plaintiff in whose favor the decree has been received to apply for execution of that decree by you can have attachment of the properties of the person or so on and so forth. There are several modes of execution, several modes where a decree once received in your favor can be executed, and execution proceedings can be initiated against the defendant, which of course remain the topic of another discussion. But in summary, and forgive the pun, in summary, if we were to look at the various options available for a particular business for the recovery of dues, which are ascertainable, which are fixed, which are calculable, and which are undoubtedly due to your business from another party or another business, then in that case a summary suit under Order 37 of the Code of Civil Procedure can be a very, very effective method to obtain speedy justice without having to go through the rigors of a regular trial, which may take several years. And this is something which you must ask your legal advisor about, which I definitely recommend to all of my clients where there is a question of recovery of dues. Apart from this, we will be coming out with several other videos to address some of the common questions which a lot of my clients or my businessmen friends will have coming out of this COVID crisis. I hope you liked it, and I will look forward to any questions or clarifications that you may have in the comments below. Thank you very much and have a great day. Please stay safe.